Welcome to the Exhibit A podcast.
Hello, you have joined us on Exhibit A, and today we have Ani Papirian, my good friend. How are you?
I'm well, thank you. And yourself?
I'm holding up. I mean, this order to stay at home and closing the businesses is a little depressing, I got to admit. The one good thing is that I'm very fortunate, just like you, that I get to go to work and, still, do something during the day rather than watch TV. But you could relate to all those people out there, I imagine, that, don't have that luxury, right?
Correct, yes.
Yeah.
A lot of my friends, a lot of people are being very badly affected, unfortunately.
Yeah, and who knows what the aftermath is going to look like. I just, if there's one saving grace, it's that we're all in it together. I tell people that if it was just against me, if it was only me that was being put through this thing, that would be really tough. But the fact that we're all in it together is going to require us, hopefully, to pull together at the end of this and get everybody up on our feet, So what do you think?
Well, I've seen a lot of community building already, and you can see it from the neighbors, you can see it from the central service providers. There's a lot being done, and I'm very impressed. But yes, it's the whole tenor outside. The people are just really scared, and you can feel it. It's palpable.
Yeah, there's good reason for it too, obviously. So, okay. Well, we are going to talk today about minors' counsel. And I thought that this would be something that that a lot of people would want to know about. I know there's a lot of mystery in people that work as minors' counsel, which you do, Ani. In a court proceeding, as you know, and I know, the judge has a lot of different avenues to take when deciding custody orders. Who gets primary custody? Who has to be on monitored visitation? What are the vacation days going to look like? I mean, all those things that come into custody orders are decided by a judge, and that judge sometimes is really at a loss as to how to proceed. So
Sure.
Before we get into minors' counsel, can you explain to our audience several of the things that the court has at its disposal? Besides minors' counsel, what else can the court do in determining child custody?
Well, in severe cases, a judge can ask for the minor to be present in court to testify. Some judges do in chambers, some don't. And it really depends on the age of that child. Another mechanism is to use forensic evaluations by experts to determine what are the issues in the case. And those are called 730 evaluations, which I'm sure you're aware of, and they're with qualified experts who are able to give an opinion based upon their education, experience, and the research they've done and the people that they've spoken to. And they could come up and be called in as witnesses or submit reports if counsel all agreed for that report to be submitted and admissible. There have been certain evidentiary changes in the rules regarding those reports and what's admissible and how you need to buttress it and so forth, but I don't want to get into that.
Not yet, at least. We'll get into that.
Yeah.
So let me cut you off here. So
Sure.
You, at some point in your legal career, determined that you wanted to be minors' counsel. And we're going to explore that because I think it's fascinating that you would devote yourself to children the way that you have. And it takes a very special person to do that. Let's talk a little bit about you. So you are a graduate of the great university, Southwestern University. Is that correct?
Southwestern University School of Law. Yeah.
Okay. Well, they've changed its name since I was in school. I graduated from the same school, but it's got a different name now. And you also have been practicing for about 18 years. You have your own law practice. Am I correct?
Correct.
Okay. And you and I have known each other for a long time, so I shouldn't have to cross-examine you. But for the audience, I'm just bringing out some facts.
Sure.
We served together on the Pasadena Bar Association. You were a trustee, right?
Correct.
For several years, and we got to know each other, and we know each other from court. We work on cases together, and I just want to thank you in advance for joining us. So what was it that made you think that, hey, this is for me? I want this niche. It's this is something I want to do rather than all the other things that you could do in the law.
As you know, I've had a varied law practice over the years. I'm very interested in the legal field. I fell into family law about 15 years ago. And since then, it's just developed and developed. And I was actually asked, my first appointment, I was asked by one of our judges if I'd like to participate and become a minors counsel. They're the ones who ask. It's not a choice that an attorney necessarily makes on their own. But if a judge sees that you have the abilities in order to fairly represent a litigant, or do a good job and do a competent job zealously, I guess that's what they look for. I'm not exactly sure. I haven't exactly asked them and all those questions, but I was asked. And then I said yes, and that just led to this career. And quite frankly, it's very fulfilling in a lot of ways. I help out families as best as I can, especially the ones that are in pro per that don't have a lot of resources, and give some light at the end of the tunnel if they're willing to take it, if they're willing to take what I say. There's a lot of challenges in this position, because you do see a lot of emotional, I shouldn't say trauma, but it is trauma. You do see a lot of emotional problems. You do get into their lives, and as much as you'd like to be as impartial as possible, there's a part of you as an attorney to be that knight and to be a zealous advocate, to go in there and to have that as part of you when you're in court and explaining to a judge the certain specific factual circumstances and what your client is going through, and then making sure that the judge understands from that child's point of view, because you're there as an advocate for that child. Okay. Now, that's the interesting part. That's the most, that's the fun part. You and I have had this discussion before about the Minors Counsel and how I feel about that role. So it's really challenging. It's a lot of work. It's draining emotionally, but it's so worthwhile.
Do you think, for our audience, Ani is the proud mom of 2 boys.
Yeah.
Do you think that by being a parent, it's helped you in working with children the way that you do?
For me, yes, because
so how has it helped you?
Because I live what I go through, certain things that experiences that I've had with my children, that helps me relate to my clients. So when my client tells me a fact pattern, gives me a story, I can actually relate it to something that's occurred, and I'll say, okay, that's a discussion I will have with my client. And then it could be as simple as gaming, which is really popular these days. It could be as mundane as taking care of the family pet. In one house you have that issue, in the other house you don't. It could be very mundane. It could be something much more serious. And
you understand kids, and a lot of times, hey, that's how kids act, where people might think that they're being brainwashed or they don't love them anymore. And you, by being a parent, you understand children, and you probably could give them some pretty rational advice, I would imagine.
Well, we try.
Yeah.
We try. And some kids want to hear it. Some kids don't want to hear it. Most do. I've seen a lot of breakthrough with a lot of these kids, and I've seen the look on their face after we have our discussion, and they realize I'm actually listening to them.
So Ani, why don't you tell our audience what the role of a minors counsel is? I mean, people think, okay, I know what a child custody evaluator is, but what is a minors counsel? What's the parameters?
Well, it's the Family Code section 3150, where it dictates your appointment. And then the Family Code section 3151 gives you your duties. And then your judge, whoever's appointing you based on the specific facts of that case, sets the parameters of your appointment. So it could be to help resolve visitation custody disputes and to create a custodial plan. A lot of people think that minors counsel is an arbiter and a decider of facts. That's not the case. And a lot of individuals also think that minors counsel can be told sensitive information and then withhold that information from the other side. That's where I always have to repeat myself. I have to be transparent. Anything you tell me, other than my client, obviously. If a party tells me anything, sends me any documents, I have to relay that information and provide it to the other side. Now, there's also other issues in tandem with that, is that some people, you get to understand and talk to people and what the true reason for their antagonistic attitude is. And that's the hard part for a lot of people. Now, as far as my role is concerned, I'm an advocate. I'm not a counselor. I'm not a therapist. I'm not a mandated reporter. I can't act in those capacities. But I am an advocate for my client. If there's an emergency, there's a situation, my client's complaining to me, I have to, and my client wants me to do an action. A lot of times I get some clients that are under the impression that they have to tell me what I need to do. Go into court. I don't want to see him or her, or get a restraining order. Well, that's not how it works. We have parameters set by a judge. In California, the policy is children need to have frequent continuing contact with both parents, and their parental bond and their relationship should not be interfered with. It should be encouraged. Way to do that is to obviously analyze the situation and place the parties into therapy. It's not regular therapy. It's a specific therapy to deal with their specific set of facts, right, and to encourage that relationship. Sometimes it's a little bit of a tough love where you have to face your own inadequacies.
So let me interrupt you for just a second and kind of break this down a little bit, because I think that the process of how you get involved and then what you do is, mysterious, and kind of complicated. So as a minors counsel, how are you appointed by the court? Is it something that the parents get to choose who the minors counsel is, or is it something that the judge orders? Tell us how that happens.
My understanding, I've never seen a parent choose a specific minors counsel. They can ask for it and make it as a relief based on certain facts of the case. Judges usually appoint minors counsel, and they have a list of qualified minors counsel, and they appoint according to what they believe their strengths and weaknesses are. A lot of it has to do with availability. First, they checked whether or not the minors counsel is available. So it's, and judges have a list of many qualified attorneys in the area that can serve in that role. And you want to make sure that they're local. So it's not a special request menu item, but that attorneys have the ability to go in and request. No, it's whatever the judge believes, and it's a best interest analysis to determine whether or not that's appropriate.
You know what I've seen, Ani? I've seen a lot of times the judges will choose the minors counsel or request that the minors counsel come into a case based upon the fit of, like you said, what's the minors counsel's role, talent, and is it a good fit for this family and particularly the children? Do you find that's most of the case for you?
Yes, and I can tell when I get some of the hardest cases assigned to me, quite frankly, and it's all interesting. It's all, it's challenging, but at the end, I'm hoping that I'm doing something positive and contributing to the quality of life of the individual.
Yeah. So when you get appointed, the judge calls you in, and what's the typical process that you take once you've been appointed? I know that the court probably orders you to do some things, but you probably have your standard procedure as well. Can you give us just a general outline as to what people would expect you to do, if you were appointed to a particular case?
I usually get in touch with counsel if counsel's involved in the case by email, and request for all documents, pleadings, orders, judgments, declarations, and the current pleadings in the case, both the filing pleadings and the initial pleadings, along with responsive or reply pleadings that have been filed. I also ask for access to the parent outside of counsel's presence, and for their contact information, their home information, availability of when I can meet with them, and along with a list of names that they would like for me to speak with, individuals who they believe are important. I don't want to waste anyone's time or money, so I don't ask for redundant information. So if you've got 5 people saying the same thing, it's not relevant.
Yeah.
What you need to do is just pick one, and then that would be sufficient. But it has to, and also the information needs to be relevant. A lot of people don't understand that hearsay testimony, hearsay statements they're not relevant. Firsthand knowledge, certain types of tangential information are relevant, obviously, but school information, therapist information, any type of disciplinary record for the child, obviously any videos that they might have of the child or the parent, that's relevant. That would be something that I would need to see. But I would obviously, this is something that, those are the types of documents and evidence that I would share. Now, however, if I'm being provided and then shown certain documents and don't have them in my possession, that's a different story.
So it sounds to me like initially what you're doing is you're gathering facts. You're inviting the parents to provide you with lists of people that you could speak to. You're doing basically an investigation. Is that right?
Yes, and actually that's what the judge asks us to do.
Okay.
How can I assist if I don't do that investigation? I try to get as much information. And with the email format, once I have that consent and I'm able to converse with the parent, I invite them to provide me as much information as possible. Face-to-face meetings isn't as important sometimes as it is with getting the information so I can take a look at. And I've also encouraged individuals to provide me, it's like their to-do list, but it's their list of complaints in the situation. And what is it specifically? Be factual. I always ask, I need to know exactly what you're complaining about so I'll know how to address it. Sometimes it's miscommunication. I've had that happen so many times, and it's caused such a problem between the parties that had they just sat down and they actually properly communicated, effectively communicated, instead of assuming things, it would have made the difference.
Yeah. Yeah. So we need to talk about your role or the part of your job where you're meeting with your clients or your clients. I mean, there's some families where you got multiple children.
Sure.
So when does that take place? Where does it take place? And what are some of the interesting things about that process? Because to me, that's the most interesting thing is you're sitting down with a child and you're talking to the child. So tell us about that experience that you go through.
Well, I don't, some minors counsel have their clients meet them in their own offices. I choose not to do that. I usually choose to go straight to their homes. And usually I visit both homes if both homes are being utilized.
Let me stop you for a second. You indicated you don't allow them to come to your office. You'd rather go to their homes. Is there a reason that you've made that a choice in your personal practice?
As a child who's going through an acrimonious dissolution matter between the parents, this will not be the first time that they've heard lots of things happen. I want to make them as comfortable as possible. And if there's things that they want to show me in their room or in the house, they need to be able to. That's part of the investigation. as well. And that's just common sense. Now, if a party refuses to allow me access to the home, that also is something that I'll report back to the court and might not be taken very, that might be considered against that party as well. Because a lot of times how these children live, their beds, their bedrooms, the common areas, whether or not they even have a bed is an issue.
Wow. So how much do you take into account the child's preference in these cases?
I don't. I report back to the court, and then I let the judge decide whatever he's going or she's going to decide, because I'm not the ultimate arbiter of or facts.
Well, let me give you a hypothetical, Ani. Let's assume that you've got a...
Sounds like law school.
But I got to know about this, and I'm sure our audience wants to know this too. Let's say that you got a 10-year-old child. She is, doing well in school. She plays soccer. She has a relationship with both parents. You find out that one of the parents has been kind of working her a little bit with respect to staying, with, let's say it's mom. Mom saying, hey, dad really can't take care of you. You should stay with me. And there's a lot of like coaching and talking and things like that. And, you start talking to your client, and your client emphatically tells you, Miss Papirian, I love my father, but I want to stay with my mom, mostly. I'll visit with him maybe every other weekend or something like that. So that information that you're receiving from your client, who you're representing, how does that make its way into the court? And are you advocating for the client? Even though you might think that there's a problem with that, are you advocating for the client, or are you doing something different?
I've had situations like that come up, so I give it time. And I note what their preferences are at what points in time. And based on that, we have discussions. And usually therapists are involved. So I inform the therapist that, you know what, there's a change that the child's identifying a preference. Maybe this is something that's a talking point that you need to have. Because as part of being minors counsel, I'm also to have allowed and permitted to have a communication with the therapist, and it's all privileged. So unlike the mother or the dad having access to the court-appointed therapist at that point in time, I am allowed to have a communication with the therapist. And if there's certain parts of the case that is a concern to me that deals directly with the child's well-being, then I'm able to have that communication with the therapist and identify my concerns, and then ask for guidance. And then based on that, I can move forward. Nothing is minors counsel don't have, they're very, how should I say it? They're very factual. So, and they have to, in order to be productive, they have to be factual. A lot of people think that because you're so factual that you're unemotional. And they come up with all kinds of fact patterns to get you to incite you, when quite frankly, that's not the situation. That's not your role. And you're more effective when you just look at the facts, and then you report on the facts, and then you deal and address the specific facts. If a child is expressing a preference, fine, let's discuss it. Let's give it time. Let's see how it pans out. 9 times out of 10, those preferences, if they're contrived, you'll find out in a matter of time.
Okay. So to make it clear, Ani, is you can depart from what your client's wishes are. If you think that there's been some, inappropriate coaching, brainwashing, or whatever, you could say, in spite of what my client's telling me, I'm advocating for this because I think this is in the best interest of the child. Am I basically correct about that?
In a sense, yes. And a lot of times when I report matters to a judge, the judge will understand, because this is what they're trained to do. They'll ask the right questions, and then it's up to the judge to determine whether or not that preference is suitable, because it's ultimately the judge's call, and whether or not they're going to consider the preference or not. It's their choice.
you sat in trials, right, where mom and dad and their respective attorneys are fighting over child custody, and you're kind of like sitting there representing the child, and you're deciding which way you want to go. You've been there before, right?
Yes.
Okay. All right. So how long do you usually stay on these cases?
To some cases, I'm in and out within a matter of months. Like, and some cases drag on for quite an extended period of time because of the facts. I've got several that I've been involved in for about 5 years now. And that's just how it is.
Yeah. So you get to be well known by the parties and possibly the children by the time that you're done with some of these cases. What are the biggest challenges you think, as minors counsel? I'll tell you what after you answer, I'm going to tell you what I think that would be for me. But what are the biggest challenges?
Keeping the parties aware of their boundaries.
Could you explain that a little bit more?
Well, getting a phone call at 8 p.m. at night.
Wow.
Or an erratic text or email, or a series of them. And having the parties understand that that's not your role. Although you attempt, because you have to be flexible as minors counsel. It's not a 9-to-5 banker's job. No, your hours range.
Wow.
And you have to make yourself accessible. But you also have to see whether or not that flexibility is being taken advantage of, and really how effective is it, you're responding to that text or phone call, how effective is it? So helping them understand their boundaries and for them to constrain themselves so that they're not, because you're the first person that they're going to blow up to. And for them to understand, making them understand that that's inappropriate behavior.
Yeah. In family law, we attorneys know that it's sometimes a dangerous contact sport because at the end of the case, you have the opposing party usually hating your guts. Even if you're trying to be really civil and be fair and do things in a reasonable way, sometimes you're demonized. And I know that from minors counsel, that's got to be a big challenge. I would think it is, because I hear my clients talking, and I'm like, oh, come on, she's doing the best she can, and your impression of what she's doing and saying is completely wrong. That's got to be a concern for you about the venom that people have towards the process.
Yes and no. Because I don't represent the parents, I don't need to deal with that. I can cut that off at a certain
That's good.
point.
That's how you're able to do the work then, apparently. I'm thinking that sometimes in your work, you've got two parents, because that old saying that a perfect case is the one where both parties walk away disappointed. I mean, some of these cases, you got both parents that are angry at, your recommendations to the court.
Yeah. And that's happened too. That's happened, I've had situations where everyone's very happy.
Good.
I've had situations where one party's not as happy as they should be, or they feel wronged. And then I've had situations where both parties feel, well, it's the whole litigation system in California in this jurisdiction. It's not too conducive to resolution. Everything has to be a matter of fight, fight, fight. And that is a mindset that they need to address, frankly. I've attended so many of the AFCC events and so forth where therapists have been talking about this for the last however many years. It's that litigation mindset that makes the situation worse.
Yeah. If
they have a mediation and a more ameliorative mindset and approach, it wouldn't get to that point.
I agree.
So it has its challenges, and I've faced all kinds of cases. I do my best given the situation. And something that parents sometimes don't realize is that when you have a really antagonistic child who does not want to be around you, is combative, and is physically strong enough and is devious enough in order to cause damage to your home and your person, sometimes it's better not to have that child in your home. And to first have a good therapeutic process and engage in that first, because you want to look at it as quality versus quantity. You don't need to spend a lot of hours with your child to prove that you love them. You love them. That's not the issue.
Yeah.
The problem is that there is a break in your relationship. You've got to deal with that first.
Yeah. So, Ani, we're coming short on time. If you were to address parents in general that are going into this process and with a minors counsel, what kind of advice would you give them as far as the type of attitude to cop, and what kind of behavior would you suggest that they engage in?
One of understanding your own limitations and your own one's own conducts and what you have done in order to contribute to the situation, even if it is a 5% versus a 50-50 situation where, the divorce happened because both of you decided at one point not to make the marriage work. And there's been a whole lot of things happening in the process which resulted to that point. Nobody else was involved other than the two of you. So if you accept your own mistakes and you learn your boundaries and you take those the therapy that's offered, be it conjoint therapy, be it parenting, co-parenting, be it your own individual anger management and how to cope with the loss, because it's a loss, it's a divorce. If you really take those to heart and actually utilize the tools that they're providing you in those therapy sessions, you're much better off and your child will be healthier and happier, right? But some people just are so blind with rage, they can't get there at all. And they might never get there. And that's sad.
I agree. I see that a lot. And I'm not minors counsel, and I see that a lot.
No, I know.
I thank you very much for joining us. That was so informative, and I hope that our audience really appreciated that, because it's actually a tough job. I think that you're kind of not being as sensitive as I would about the stresses that are involved. Those strange hours, working in distressed families and stuff. So I really appreciate you coming and joining us on Exhibit A.
My pleasure. You have a good day. Be safe.
Okay. And we will see you again next time on Exhibit A.
For more information, visit us at PasadenaLawOffice.com.